Good morning, everyone. I would like to call to order this hearing of the Judiciary, Finance, and Civil Law Committee. Today, according to my sheet, I've lost track, but it is Thursday, March 26th, so they say. And so I want to note at the outset that this hearing has been approved for extra time, so we will adjourn at approximately 12:30 today. And we do have a quorum present. So I'm going to first read the safety notice that we read at each hearing. So we want to, of course, maintain a productive and safe environment. So we're going to ask all attendees to maintain a high standard of decorum. Signs are not permitted in the hearing room. Please refrain from applause or other audible demonstrations. Verbal outbursts, shouting, or disruptive behavior are not permitted. Testifiers must limit their remarks to the specified time, and that today is 2 minutes. For safety reasons, do not stand or sit in the aisles. If you need seating accommodations, alert the sergeant staff wearing the gold ties. If you have an entrance ticket, please keep it with you. You may need it for re-entry should you leave the room, and I think we are today using tickets, and we are tight on space, so please observe that. We have state troopers and sergeant staff stationed throughout the room to ensure everyone's safety. So, again, 2-minute limit for testimony. We have a very full agenda today. And we have a lot to get through. Okay, first bill on the agenda is Senate File 1750. Representative Bahner is here to present that. And so the chair moves that Senate File 1750 be placed on the general register. There is an amendment. It is a D13 amendment, which I have spoken with Representative Bahner. She would like to adopt that first, and then we'll discuss it. Apparently, the changes in it are very minor, and she will discuss them as we go through it. So, all in favor of adoption of the DE13 amendment, please say aye. Any opposed? Motion prevails. The amendment is adopted. So, Representative Bahner, to your bill as amended.
And Madam Chair, I'm just going to throw this out here, and I'm sorry I had forgotten about this. When reviewing the amendment last night, we did realize that there was one line that we had intended to strike in the amendment that we did not. And I'm wondering if you would be willing to entertain an oral amendment. It is specifically on lines 15.8 and 15.9. It directs that an individual may have an attorney present during a dispute resolution. And the reason for striking that was that we did not want to automatically presume that they had to have an attorney, which could then cause the association to have an attorney and attorney's fees to get accrued. And it is not our desire to make unnecessary attorney's fees.
Okay, thank you, Representative Bahner. So I'm going to turn to Mr. Hopkins. Oh, okay, Ms. Davis, yes.
Hi, chairs and member, this is Mary Davis from House Research. The oral, it is, yeah, I can move closer. The oral amendment is page 15, line 8, delete everything after the period. Page 15, line 9, delete everything before the period. Is that correct?
All right, does everyone have that oral amendment? So just striking a sentence there that begins on line 15.8 and goes on to 15.9. Is there any discussion to the oral amendment? All right, seeing none, all in favor of adoption of the oral amendment, please say aye. Aye. Any opposed? Motion prevails. The amendment is adopted. Okay, now that we have the bill in shape, Representative Bahner.
Yes, and first I want to say a hearty thank you to Mary Davis for Ms. Davis for all of her hard work. We missed that, and so I want to claim our mistake. She is a phenomenal asset to us. So with that, as promised, Madam Chair, I know we want to be very concise with our time today, and specifically who had asked us to confine our remarks and testimony for all of us into the areas within the jurisdiction of this committee. As I understand it, the 3 areas that are most likely to hit the jurisdiction of this committee involve the conflict of interest, the foreclosure sections, and the attorney fees. And so in agreement with that, I will briefly go through those and then turn it over to the testifiers. First, the conflict of interest section. This section briefly requires transparency through disclosure for board and property management folks. It has provisions to prevent personal financial gains or self-dealing, prohibits board members from participating in deliberations or voting, which could result in a financial interest to those board members or an immediate family member, requires the board to seek multiple bids, and sets a minimum at 3 for maintenance, construction, and reconstruction over $50,000. It provides for a number of exceptions, namely things like emergency repairs, warranty issues, volunteer labor, or when it's simply not accessible for several reasons. It requires the boards to keep records of those bids. It does have a couple important caveats. It does not require that you select the cheapest vendor, but it does allow for flexibility in your vendor selection for things like quality and time to completion. The second section that's applicable here is the legal fees, and specifically that section speaks to charging attorney fees for homeowners. It says that you cannot prohibit attorney fees for asking basic questions, requesting a dispute resolution for a grievance, and refers that over to the ombudsman if it's unresolved. It sets a timeline around those disputes. You must request one within a 30-day limit, and it requires the disclosure of to the homeowner that they may incur attorney fees for more complex questions. So it cues that up. On the foreclosure front, we seek to really, with this section, create greater parity between non-HOA practices and HOA practices. It limits foreclosure to unpaid assessments over 3 months and prohibitions on foreclosure for minor fees, which was a major takeaway from a lot of our listening sessions around the cities here. It does have a few exceptions around things like immediate impact on health and safety, if it causes physical damage to a unit or element, or it involves the illegal use of the unit for things like an Airbnb. And then I will briefly mention the amendment we just put together. It has primarily small technical changes and reference updates, but the 3 substantive things in there, we do have a definition of retaliation that was added to add additional clarification. We worked in consultation with the Minnesota Bar, with stakeholders and legal aid. It prevents retaliation, but it also clarifies that paying your bills, or failure to pay your bills, resulting in foreclosure is not retaliation. And further, we add a clarification on property management contracts. This was negotiated with stakeholders as well. It allows for the termination within 12 months after the transition from the declarant control period to the elected board. It then allows the board to have the flexibility to choose going forward. It also sets a parameter around auto renewal of contracts to have a 3-month notice to opt out of that contract if the parties desire. And if it has an auto renewal, or if it does not have an auto renewal, it sets up a 3-month notice to allow for termination. And there is also one last provision which was stricken in an earlier version, but stakeholders requested we bring it back and add some additional comfort language around sort of basic meetings for daily operations, maintenance, and management, sort of the status of how is the sidewalk project sort of coming, that do not require notices or meeting notes for those. And the rest was highly technical. That is it in a nutshell. And I know we promised to keep specifically to what was in your jurisdiction, and I have asked my testifiers to do so as well. I will let you note that there are several letters in your packet in support of the bill, as well as some from our stakeholders that we've been working with and working quite closely to negotiate the nitty-gritty details of this and working in good faith to do so. I do have Ron Elwood from Legal Aid here. He will actually not need to testify. He will just be here for questions, so you can proceed with the other testifiers.
All right, thank you very much. Representative Bahner, appreciate it. Okay, we'll move to testifiers then. Mark Lewis Foster. Is that virtual? No. Oh, okay. So after Mr. Foster will be Joel Carlson, then Matthew Greenstein. So if you could be ready to come up. And welcome to the committee, Mr. Foster. So we're going to ask you to please state your name for the record and go ahead, but you have 2 minutes, and we're going to be, because of our tight schedule today, we're going to be timing everyone. So you get to set the pace here.
Yes,
Welcome.
thank you, Madam Chair, members of the committee, ladies and gentlemen, good morning. Thank you for this opportunity to testify. I am Mark Lewis Foster. I'm co-owner of the HOA Leadership Network. We are an education association that meets monthly in 5 chapter locations in the metro to provide important educational presentations to active board leaders who represent more than 1,000 HOAs in the metro area and counting. You'll hear plenty today about 1750 and its various components. I'd like to take this opportunity this morning to provide some perspective about board leaders. Just in the past 2 years, I have facilitated more than 90 two-hour chapter meetings with volunteer board members from across the metro. We find these board leaders to be engaged, smart, and well-informed, with an overwhelming desire to do the right thing for their homeowners and HOA properties. We find board leaders want help to interpret and apply current Kiowa legislation, their own governing documents, and rules and regs in a consistent, fair manner. They want to ensure their associations are properly funded in challenging times. The last thing they want or need is more legislation. As elected officials, if you're looking to clarify a path forward for board leaders or to make things simpler, more efficient, and less burdensome, this is not the bill. If you're looking to encourage future board leaders to join a board with enthusiasm, this is not the bill. Our view is that board leaders want education, not more legislation. The HOA ecosphere, while growing, is already stressed and thin from a lack of volunteers who are waiting in the wings to help or join a board. Our network is proof that education is the right path. Becoming stronger in financial matters, governance, and application of current law is the outcome when educational opportunities are provided to board leaders. I encourage this body to reject the bill. I invite you all,
Have to ask you to
please,
wrap
to
up.
attend a future HOA Leadership Network chapter meeting. Our next one is Tuesday in Maple Grove. Come see for yourself how education is a great alternative. Thank you so much.
Thank you. Joel Carlson, Matthew Greenstein, and then Cindy Haas. And I would just really ask everyone to please, if you can, keep your comments to the subject matter of the, before the committee. Welcome to the committee. Go ahead, Mr. Carlson. 2 minutes, please.
Good morning, Madam Chair and members. I'm Joel Carlson. I own a legal research and government affairs business here in St. Paul, and I represent the Greenstein Sellers law firm and a number of their affiliated clients that include homeowners, homeowner associations, boards, management companies. And we're here with significant concerns about this bill. And this bill affects the property rights of about 1.5 million Minnesotans that live in residential common interest communities. I want to contrast this bill with the 91-page bill you had yesterday that had hardly any comment because it had been thoroughly vetted, it had been understood by the participants, and everyone was in agreement that these were appropriate changes as it impacted everyone's property rights. We're now on DE 13 of this bill that is changed even this morning, And this has not been vetted appropriately in our estimation. And while there are many things in this bill that help homeowners with transparency and disclosure that we support, there are significant cost shifts in here. And this comes at a time when Fannie Mae, just on May 18th or March 18th, just published new guidelines for what HOAs have to do to meet their reserve requirements. They increased those reserve requirements by 50%. That is going to increase the cost for everybody who lives in a HOA, and this bill is going to add to that. I think everything in this bill is in 515B is within the jurisdiction of this committee, but I want to point you to just two things. On page 18, which has not been vetted, a provision was added in one of the DEs, I think it was 12, to require an HOA board to refer every unresolved dispute to the new ombudsperson at the Department of Commerce. You are talking about thousands of referrals that are mandatory in this bill on page 18, lines 1 through 3. That is going to have a huge cost to the Department of Commerce. And also, this bill has not been to local government, and you preempt local governments in section 16. And that has also not been properly
Thank you,
vetted.
Mr.
Thank you, Madam
Carlson.
Chair and members.
Next is Matthew Greenstein, and then Cindy Haas, and then it'll be Debbie Watson, if you could be ready to come up.
Thank you, Madam Chair. My name
Welcome,
is Matt Greenstein. I'm an attorney representing common interest communities and homeowners throughout the state of Minnesota. I appreciate the work done by the authors on this legislation because some language that has been added to the bill and incorporated is good policy and based on best practices. However, there is a large portion of this legislation that is not the consensus of the stakeholders, that is not based on best practices, and will have detrimental impacts to millions of homeowners in the state of Minnesota. 1750 has not been endorsed by the State Bar Association. The only bill endorsed by the Minnesota State Bar Association on HOAs is House File 3459, which was vetted over the course of many years and thoughtfully crafted in order to ensure accuracy and legally sound changes. The current bill before you is legally problematic in many sections. These have been raised with the authors. Many sections require individual directors to negotiate and deal with homeowners directly, requiring them to negotiate deals with individuals. The problem with that, while good on its face, and we want to have dispute resolution and resolve grievances, is that the Board of Directors' legal obligation under Minnesota law is to make decisions in the best interest of the association as a whole. There is not a legally sound way a deal can be made with every homeowner who has a differing opinion or grievance with the association. And the legal obligations under 515B, Chapter 317A, and upheld by the Minnesota Court of Appeals require boards to act in the best interest of the association as a whole. Even revisions that were just done in DE 13 contradict other sections in 515B. The ability for board members to meet outside of an open meeting to discuss association matters violates the open meeting requirements that are already in place as a protection for homeowners and to ensure transparency in how board members operate. Other provisions throughout this draft have technical errors,
You have to ask you to
misused
wrap up,
terms,
please.
and are ambiguous. And I would urge the committee to consider this bill and make sure it's legal appropriate before moving it forward.
Thank you. Cindy Haas, and then Debbie Watson, and the Julianne, sorry. Welcome to the committee.
Okay. This is not my profession. I have really no idea what I'm doing here, so I'm just going to throw this out here.
Okay,
Please.
state your name first, please.
My name is Cindy Haase. Madam Chair, I'm going to ask for a little grace on the time because
Well, I'm sorry, we don't have time to
I'll
give
read
grace.
fast.
You have to do the 2
I will
minutes.
read fast. And then, again, just give me some grace in terms of this is not necessarily my profession, and I was not told that I had to stick strictly to jurisdiction. So my name is Cindy, and I'm a current board member, having served approximately 10 years. Our association is considered average to large in the industry, and I am going to share with you today some actual numbers. My primary concern is the impact to governance that these legislative changes and/or additions will create without any regard for the many different types of associations and structures of HOAs. In our association, elected boards have the authority to approve an insurance policy with a building coverage of $48 million and a premium of $156,000, but will no longer be able to determine the appropriate amount of a late fee for their association based on its specific needs. Elected boards currently set budgets resulting in collecting dues to contract professionals in the ballpark of $630,000 annually, but will no longer be able to determine the appropriate amount of a rule fine for their associations. Boards can't approve a fine over $100 without going to an annual meeting. We all know getting an annual meeting for an HOA is near to impossible. Elected boards currently run associations' day-to-day activities using complex tools such as reserve studies, budgets, preventive maintenance plans, and web portals, but will no longer be able to determine a one-page collection policy that says 30-day letter, 60-day letter, 90-day letter, and then off to the attorney, nor allowed to leave a policy in place that has historically proven successful. Elected boards are managing reserve funds, often in the millions, in my case 1.7, and approving the reinvestment of called CDs and bonds totaling $140,000 per month with banks and financial planners, but can't approve a $50,000 contract without jumping through hoops to be compliant with this new legislation. At the last hearing, there was a question about whether these board members have education for their roles. I can attest that yes, we do, through many professionals in this entire state. My overriding concern is the feeling in all of these legislative hearings that something has to be done.
I have to
These
ask you to
HOAs
wrap
need
up,
to be
please.
saved. I'll wrap it up. Need to be saved by legislation. We must act because this committee put in hours and hours of work and has this very lengthy spreadsheet. We don't need to be saved by legislation. My recommendation in closing is that we slow our roll and we respect the fact that we've already done some great work. We've put an ombudsman
I have to ask you to
position
conclude.
in place, and I would ask you to allow that person to do their work for the next 2 years
Thank
before
you.
approving this bill.
Debbie Watson, welcome to the committee. Are you?
No.
Watson, okay. Debbie Watson is next, then Julianne Uzlik, then Matt McNeil. Welcome to the committee. Please state your name and go ahead
My
with your
name is
testimony.
Debbie Watson. I'm the president of Colonial Patriot Homeowners Association, and I want to speak to 3 specific items. Section 5 prohibits an association from imposing a late fee greater than $15 for late payments of assessments, except for that of special assessments. $15 is an insignificant amount of money. The way that our association works is that we give you a notice that you're late. You get 30 days to make your account current, and then we charge you a $25 late fee. We have people that will ignore those late fees until they become in the hundreds of dollars because they consider it not worth their while to bother with. So we've got to have some ability to hold people accountable for failure to pay their bills. For example, we had one individual who just ignored his assessments and his late fees until such time it was in the multiple thousands of dollars. And that has a direct impact on how we budget and what our money is that's available for us to take care of our communities. There's no distinction between association types or sizes. A 10-unit association is run significantly differently than an association like mine, which has 176 homeowners, 67% of which are landlords who rent their units out, who never come to annual meetings, but will send someone with 40 to 45 proxies, as they did last year, to put an individual on the board because nobody else came with enough votes to be able to vote anybody else on. Contracting requirements requires competitive bids. Sometimes we can't get 3 competitive bids.
Okay, I
And-
have to ask you to wrap up, please.
Yep. And in ending, please look at this as if you are a homeowner in an HOA and whether you would want to tie the hands of the board to function, keeping in mind that all boards are run by volunteers who give their time unpaid to work for the betterment of our community and to ensure that property values do not decline because we cannot
Okay,
take care of the
thank you for your testimony. Julianne Uzlik and then Matt McNeil. Welcome.
Chairs, Representative Liebling and Representative Scott and members of the House Judiciary Committee. My name is Julianne Uzlik, and I have lived in a common interest community for over 35 years in Bloomington. I currently serve on the Board of Directors, which is elected by the homeowners. I speak in opposition to Senate File Number 1750. Despite its stated interest to protect unit owners, the proposed amendments would cause serious legal and financial harm to the common interests of our community they purport to serve. And the committee is respectfully urged to vote against this bill. Unit owners voluntarily purchase into common interest communities with full knowledge of their governing documents. DE 12 overrides these agreements by imposing sweeping state regulations on internal association operations, substituting legislative preference for community self-governance. The MCIOA already provides robust owner protections. This bill does not fill gaps. It supplants the informed judgment of communities with one-size-fits-all mandates that penalize well-run associations for the alleged misconduct of others. Just a quick reference to the assessment collection amendment, which does create an unrecoverable cost shift onto compliant owners. And if we can't collect our fees and owed monthly assessments, we can't manage the budget as already previously stated. We can't imagine the budget to accomplish the needs of the community. Here's a quick example. The insurance industry that offers coverage for these types of associations are very rare now.
I have to ask you to wrap up.
To wrap up, I thank you for your attention and the opportunity to testify. This bill is wrong. Please vote against it.
Thank you. Matt McNeil, welcome.
Good morning and thank you. My name is Matt McNeil and I'm the president of Cities Management. Co-chairs Liebling and Scott, members of the committee, I really appreciate the opportunity to testify this morning. Cities Management is one of 4 management firms in the Associa family of companies operating here in Minnesota. Collectively, we serve more than 750 homeowners associations and 70,000 homeowners across the state. We're here today on their behalf. We certainly support reform, and we believe good policy is informed by the members we serve day in and day out. Good policy for homeowners should support effective, efficient, and even-handed governance from the board and its direction to management. Contrary to what you have heard, this bill does not have stakeholder support. You're hearing that here today. You've heard it in emails and phone calls that you've received. Our clients, your voters, are going to be negatively impacted by this bill and have shared their concerns with you and with us. The core issues this bill creates remain unaddressed. They deserve more due diligence and, quite frankly, restraint. It's not ready to become law. Minnesota homeowners are already absorbing historic increases in insurance premiums, expanded reserve requirements, and growing maintenance obligations. The financial margin in these communities is beyond thin. This bill, as written, shifts additional cost onto the compliant owners who pay on time, follow the rules, and depend on the association to function. As enforcement tools are restricted and collection timelines are extended, it's not the delinquent owner who absorbs that cost, it's the compliant neighbor. We would ask the committee to consider the unintended consequences. For example, under Fannie Mae's updated standards, a condominium will lose eligibility for conventional financing when delinquencies reach just 15%. That affects property values, buyer access, and the investment every owner has made in their own community. This bill is broader than the problem it intends to solve, and it's arriving at the worst possible time for Minnesota homeowners, already under a financial
All right,
crisis.
I'm sorry, your time is up.
We are ready to be a genuine partner in getting this right. We ask that you support making room in the process for that. I really appreciate your time this morning.
Thank you.
And thank you.
Okay, there are no further testifiers, so we will go to member discussion. Representative Feist.
Thank you, Madam Chair. Thank you so much, Representative Bahner, for your work on this bill, for not just the DE 13 from this session, but the last, I believe, 3 years. We get a lot of emails from our constituents, and a lot of times they like click on a button and it sends a template, and I appreciate those because I still know what my constituents want me to know. But I can't think of another issue where more people have emailed me in my 3 terms that like personally pleading for help and solutions than the issues that this bill seeks to address. I've had coffee dates with my constituents where they have just, I've just filled notebooks with their stories of the ways that they have felt powerless, that they have experienced direct harm to their homes and had no recourse, that they felt there's this lack of transparency and accountability. And I just I feel their frustration. And I'm just grateful to you. We all have our things that we focus on, and I'm glad that you focused for so long and so hard on this issue. And I just think this is really important. One of the testifiers said that education is the answer. Sometimes legislation is the answer. Sometimes, there are issues that do require a statewide solution, and I think this is absolutely one of those. And I know how hard you've worked on this, and just on your behalf, since you're classy, and you're just gonna, you sit there and you listen to people say that you're moving too fast and you're not listening, but you have. And I appreciate you, and I appreciate the work that you and Mr. Elwood have done, and I strongly support this legislation. Thank you.
Representative Hudson.
Thank you, Madam Chair. I'm fascinated by the diversity of the opposition to this, none of which seem to address a lot of things that the bill actually does. So, conflicts of interest, the ways in which there's self-dealing taking place, the amount of leverage that these organizations have over people's homes and therefore their lives and their families. The idea that putting in these simple good governance principles is somehow going to be a harm to the homeowner is something that I'm not convinced of. And I would just echo Representative Feist's acknowledgement of the amount of work that you have done. I know, been privy, not directly involved, but privy to the conversations. And also DE 13 seems pretty well vetted to me. It's the bills that keep getting amended that are the ones that are getting worked on. And in terms of stakeholder consensus, sometimes we don't get to have that because sometimes the imbalance of the status quo is such that certain stakeholders are going to lose something. They're going to lose control. They're potentially going to lose some money. But there's been an imbalance there in the way that control and funding has been distributed. So thank you for the work you've done on this.
Representative Van Binsberger.
Oops, thanks. I just want to speak on this. I've been in this space as a business owner in a similar space for close to 25 years. And, I've listened to the testifiers today. A couple questions I have for the author of the bill is, obviously, what kind of stakeholder involvement has been in this? I'm concerned about the disputes that are going to resonate from this new law and what we're creating here, and it's going to go to the Office of Ombudsman. Can you give me some explanation of, does the Department of Commerce have that ability to service what is likely coming their way? Or are we going to have to hire some more employees? Are you going to be back before the legislature next year saying, hey, we've got this issue and we've got so many complaints, so many calls coming in, hey, we got to hire another 10 people here at the Department of Commerce to handle this. Can you give me a little explanation behind that?
Representative Bahner.
Thank you. I know this is not in the jurisdiction of the committee, but I do want to say, first of all, we've heard a lot about the sheer volume of complaints about homeowners associations. And this part of statute has not been amended in almost 32 years, really. Not in any substantive way. This bill has started and progressed over about 2.5 years. It started with a working group in which stakeholders sat on that working group. They were folks from the CAI, which represents property managers and boards, the Home Ownership Center, the Housing Justice Center, legal aid, property management folks, the Minnesota Bar, individual homeowners. It was a pretty diverse group, actually. Out of that, we created a set of recommendations for changes within the statute to move forward. Those recommendations were approved by all of the stakeholders, including those who continue to be at the table today. That formed the basis of this bill, and over the next year and a half or so, we had listening sessions in all corners of the state here to try and hear from individual homeowners, board members, and including some property management folks. We took all of that feedback, and we have reviewed hundreds of potential change requests to this bill. And we have reviewed each and every one line by line on its merits, consulted with legal experts and with counsel, and made appropriate decisions with all 4 bipartisan authors. To make it in this bill, it had to have bipartisan agreement. So, and we have continued that work with stakeholders throughout the entirety of this time, and we continue that today. And in fact, the DE you saw today, the changes there reflect additional changes that we have come to an agreement on with stakeholders. And we continue to act in good faith as we have all the way along.
All right. Anything further?
Yeah.
Yeah, and please be brief. And let me just say before you speak, Representative, so I think we're going to change the motion and send the bill not to the general register, but to, and I will give you a chance to speak on that, Representative Bahner, but I think probably local government? GovOps. Election, so it would be elections, finance, and GovOps, but I will let you speak. I'm just wanting to we will, before we do that, Representative Bahner, I will let you speak on it, and I will ask for your response to that idea.
Okay.
But I just want members to know that as we continue, because I do want to move this along, and we are past the time allocated for this bill. So if you would, everyone could please be brief. Anyway,
Okay,
go ahead, Representative.
Thank you, Madam Chair. I'll be brief. First of all, you didn't answer my question about the process about handling the complaints in the ombudsman office and how that's going to happen. I know a lot of these associations, they function on very tight budgets. There's little money in a lot of these accounts. They're ran by volunteers, people just doing their best, and they're working with management companies and the homeowners. They work together. You know, we can't legislate, we can't create rules for everything there is out there. So, you know, I do not support this bill.
All right, thank you. So we missed a testifier, and so Patrick Hines. So we're going to let Mr. Hines testify, and then we're going to have closing comments, and we'll discuss the issue of where the bill should go, and then we will take a vote on the bill. Mr. Hines, you have 2 minutes. Welcome.
Thank you, Madam Chair and members. Patrick Hines with Messerly Kramer for the Community Associations Institute, whose members include homeowners, homeowner board members, property managers, lawyers, contractors, and really anyone who works regularly with homeowner associations. I do want to thank Representative Bahner, Representative Cagle, and O'Driscoll, and many other legislators who've worked very hard on a bill. It's been a long process. It's come a long way from when it was introduced, and we appreciate many of the changes. I won't go through them all. I'll just note as an example on page 8, there's a new provision related to the termination of a limited set of HOAs. There were some problems brought forward by Habitat for Humanity, and I think we all work together to address that. There are still some issues we're working on. I would just note one is a provision on page 17 that requires or prohibits associations from applying payments to late fees and fines before they pay for their assessments. I understand the intent of this provision. I do think the way it's drafted, it creates an avenue for abuse because a person could simply pay their $250 monthly dues each month and never pay the fine. And some of the other changes give the association little recourse to collect on it. I don't think that's fatal to the, passing it out of committee today. I think we can still work on the language to make sure the unintended consequences aren't there. But, it's still a work in progress. I don't know if it's at prime time yet, but it's close, like that time when my mom watches Jeopardy, perhaps right before prime time. So, thank you.
Thank you. And you came in under 2 minutes. Thank you very much. Thank you for that. So we are, because of the preemption issue, we were considering sending this to local government, Representative Bahner. So I'm going to.
Thank you.
So it would be Elections, Finance, and GovOps is the actual name of the committee.
Yes.
So would you go ahead and make a closing comment, if you would just address that?
Yeah.
And
Madam
please be
Chair,
brief, yeah.
Yes, I just want to be very crystal clear. That section of the bill has already been to local government. It was also been running parallel tracks with a standalone version of the identical language. It has been heard in local government. It was then passed on to housing and has also passed through housing as well. So that section of the bill has been addressed. When I had spoken with Chair Freiberg, he did not feel the need for it to go back to him, but certainly we could confirm that with him. But on my last conversation with him, he did not feel that it needed to go back.
Okay, thank you, Representative Bahner. Representative Engen, I had taken you off the list, but putting you back on. Go ahead.
Thank you, Madam Chair. I'm sorry, I'm
That's
all
all
over
right.
the place today. Has MSBA vetted this bill?
Yes. Representative Bahner.
Yes, multiple times, and has provided copious amounts of. Oh.
Okay.
The subcommittee within the bar that specializes in these issues has reviewed the bill on multiple occasions and has provided, the chair of that committee has provided copious notes throughout the process, and a lot of their feedback has been incorporated into each and every iteration of the bill.
Okay, so I see
Matt.
Mr. Lake is standing up, but let him come up and respond to the question, I guess. Welcome to the committee.
Thank you, Madam Chair. I'll be very brief. Brian Lake, I represent the State Bar Association. I just want to be clear for the legislative record. We have no position on the bill. We are not supportive. We are not opposed. We're not neutral. This is a very large bill. We've done our best to review it. There just simply isn't time with the different iterations for us to go through and have a formal opinion on it. As Representative Bahner mentioned, Tom Bray, who was here testifying on Representative Feist's bill yesterday, is the chair of the bar's McIowa subcommittee. Mr. Bray, in his personal capacity, has offered enormous amount of advice on the bill, but that is in his personal capacity. He does not have a personal public position on the bill, but he's just offered his technical expertise and advice on the bill, and that is the extent of our involvement.
All right, thank you very much. So we're going to move to a vote, and before we do that, and so we're going to keep the original motion. So the motion is that the Senate File 1750, the first unofficial engrossment as amended, be re-referred to the General Register. And before we vote on that, I will just say that, like all bills, a member's vote on this bill is to move it out of committee to the General Register. It is not saying the bill is perfect. It is not saying that we would vote for it on the floor or anything of the kind. I just want to make that very clear. And I also just want to say publicly that I believe that Representative Bahner has done an amazing amount of work and engaged in an incredible amount of stakeholder work on this bill. I know her work ethic. I know that she will continue to listen and work on the bill, and I also appreciate the assistance of Mr. Elwood, who did not speak, but I know he's been deeply engaged on this bill. This bill is attempting to solve some real, very real problems, and sometimes it is difficult to get to the perfect solution, but if a perfect solution can be found, I think this team will do it. So with that, all in favor of the motion, please say aye. Aye. Any opposed? No. Motion prevails, and the bill is moved to the General Register. Thank you, and thank you to all the testifiers. All right, moving on. The next bill on the calendar is House File 2700, Representative Elkins. And so as Representative Elkins comes up, the chair will move that House File 2700 be placed on the general register. There is an amendment to the bill. And please, folks could be very quiet while leaving or coming in. We would appreciate it. Okay, let's see. There is an amendment,
Yep, the chair's
A8 amendment, and is that?
author's amendment is A8.
That is the author's amendment. Thank you, Representative Elkins. And Representative Elkins, maybe it would make more sense for you just to give the brief, quick overview of the bill before we adopt the amendment, or would you rather just adopt it?
The amendment basically reflects all of the feedback that I've had from stakeholders between the time the bill left Commerce and the time it arrived here. Most of it is wordsmithing.
Okay, so let me then I will then move the A8 amendment. Is there any discussion to the A8 amendment before we adopt it? Seeing none, all in favor, please say aye. Aye. Any opposed? Motion prevails. The amendment is adopted. Go ahead to your bill as amended.
Thank you, Madam Chair. I'll try and keep this quick. Basically, this bill adds a definition of health data to the Minnesota Consumer Data Privacy Act. It covers the types of health data that are collected by your wearable devices or health apps that you might use, and classifies it as sensitive personal data under the Act. The consequence of classifying it as sensitive data is that it means that that data cannot be sold, or in this case, shared with other parties without your express prior commitment. So it's an opt-in rather than an opt-out. The bill also defines the term geofencing and prohibits geofencing from being used to identify your visits to healthcare facilities of any kind. Yeah, that's pretty much it in a nutshell. So what we're trying to do is protect the data from your wearables and your devices, and make it sensitive data. So the aspects of it that I had most conversation about with stakeholders were adding geofencing to the bill, but as long as people understood that it was geofencing for the purposes of identifying your visit to a healthcare facility, people seemed to be okay. The other thing that's added that I had a lot of conversation about is adding the definition of sharing of data. For the most part, the Act only restricts the sale of data, but a lot of the data of this nature seems to change hands without the exchange of money or other valuable consideration. And so I've added the definition of sharing in here and saying that health data cannot be sold or shared without your advance permission.
All right, well, thank you, Representative Elkins. So we have one testifier signed up, and that is Andy Kingman. And Andy Kingman is on Zoom, I believe. Welcome to the committee.
Good morning. Can folks hear me okay?
We can, and please introduce yourself in 2 minutes, please.
Absolutely. Good morning, everyone. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We're a multi-sector group. I also have a background as a privacy compliance attorney. I want to make it clear we support heightened protections for health data. Conceptually, we don't have any opposition to that. We also greatly respect and appreciate Representative Elkins. We know he comes to this bill with good intentions and look forward to continuing to work with him as we did on the comprehensive bill. Our two concerns here are with the concept of share and with the geofencing provisions. On the definition of share, this concept is already included in the definition of sale. No other state that has this consensus comprehensive framework that Minnesota has adopted has a definition of share in it, because again, that concept is already included in the very broad definition of sale. When this framework was being worked on in various states across the country, the definition of sale was made intentionally broad to cover any kind of exchange of data for monetary or non-monetary consideration. So anytime there is a contract in place for an exchange of data, it is considered a sale. This was done to ensure that the opt-out rights for the consumer applied as broadly as possible. And additionally, consent already is required for any processing of sensitive data, which will include health data. And so we view the definition of share as unnecessary, and because it overlaps so closely with sale, very confusing. And then lastly, with the geofencing provisions, again, we don't object to having geofencing provisions, but right now they are not limited either by distance or by the type of facility that is offered. And so we've got concerns about the overbroad drafting there.
Okay, I have to ask you to wrap it up, please. 2 minutes are done.
Right on time.
Thank you very much. Appreciate that. Okay, there are no further testifiers. We will move to member discussion. Chair Scott.
Thank you, Madam Chair, and thank you, Representative Elkins, for the bill. And we share concerns, common concerns on data privacy and that sort of thing. So I get what your bill's doing. I do think the testifier brought up a couple of good points, and then the letter from the chamber about just determining what falls into the category. So if I go to Target, or if I go to the store and I buy over-the-counter aspirin, and the example given in this letter, is that considered health data? I certainly wouldn't expect that to be considered health data to me, but I think there may be some confusion out there in the marketplace as to categorizing something like that.
Yeah, and the
Representative Elkins.
Madam Chair, Representative Chair Scott, had a lot of discussions about this, but remember that when you classify data as sensitive under the Minnesota Consumer Data Privacy Act, the only thing you're really restricting is the sale, or in this case, also sharing of the data. So if Walgreens of course records the fact that you bought aspirin or anything else you might buy in their pharmacy, but the only thing that's restricted is them then selling the data without your permission or sharing it. As long as they're just using it internally to provide services that you've requested, you're fine. I had to have that conversation with about a half dozen stakeholders.
All right.
Chair Scott.
Thank you. I appreciate the explanation.
All right, Representative Durant.
Thank you, Madam Chair, and this might be actually for nonpartisan here. I'm just a little confused on the geofence issue here, and I was wondering if maybe Mr. Hopkins or someone can walk us through the, I guess, the limitations this is going to be able to maybe, I guess, not maybe hinder law enforcement's ability to do some investigation, because I've had very bad people do some nefarious things in some very vulnerable places in order for us to be able to use all the tools in law enforcement. Would this hinder their ability to do other investigations besides just identifying people for medical purposes?
Mr. Hopkins.
Madam Chair, Representative Duran, so the Consumer Data Privacy Act in 325M that this is amending does not apply to government entities, so it wouldn't apply to law enforcement.
We're good. Okay. All right. Is anyone else on the list? All right. No one else is on the list, and so Representative Elkins, any
it's a good
very
bill.
brief
Please vote
concluding
yes.
remarks? Please vote yes. I love that. Okay. The chair renews the motion that House File 2700, the first engrossment as amended, be placed on the general register. All in favor of the motion, please say aye. Any opposed? Motion prevails. Thank you. Thank you for all your work, Representative Elkins. All right, next on the agenda is House File 1606, Representative Hanson. And while Representative Hanson is coming up, I will move that House File 1606, the first engrossment, and I think we're going to amend it, so it will be as amended, is to be placed on the general register. And there is an amendment, the A2, and that is the A2 is an author's amendment. Am I correct, Representative Hanson?
Correct, Chair.
And that just, as I understand it, it just makes the definition more clear.
Correct, Chair. It defines what an identifiable individual is.
Okay, thank you. So any discussion to the A2 amendment? All in favor of the A2, please say aye. Any opposed? Motion prevails. The A2 is adopted. And then we will go to your presentation. So welcome to the committee. Please go ahead.
Thank you, Chair, and thank you, members, for your time today. I want to start by saying a few things before I get into the details of this bill. The information that we'll share today is pretty graphic. It can be disturbing, and it can be particularly disturbing for folks who have experienced the tragedy of sexual violence or gender-based violence and gender-based hate crimes. I want to also name that sharing the stories like what you'll hear today on the public stage takes an indescribable amount of courage, strength, and support. And I want to thank our testifiers who are here with us today for allowing me and this body to join them on their mission to advocate and create change so that fewer people have to endure what they have. So moving on to the bill. House File 1606 defines nudified content, and it requires that nudifying features on apps, platforms, and websites be turned off in Minnesota. It also prohibits advertisement and promotion of platforms with a nudifying option on social media or other websites. And lastly, the bill establishes civil penalties and remedies. This bill narrowly and specifically bans the tools and features of technology that are used to create nudified content while still ensuring that First Amendment protected activities involving technical skill remain exempted. Now, while AI technology can be used for good in many ways, it can be also used for harm. Governing bodies around the globe have failed to adequately regulate many aspects of AI in a timely manner, so I am really proud of the legislature for taking this step today because it's always a good time to do the right thing. The dark reality is that child sexual abuse material and other sexually violent and predatory AI-generated material support one of the most profitable supply chains of commerce that reach around the globe. And the Nudify feature that this bill seeks to ban allows predators to create this content en masse to only further increase their profits. So what do these apps do? Nudifying features enable others to, among other things, create unauthorized, deepfake, non-consensual porn and other non-consensual sexually explicit content and child sexual abuse material by simply clicking a Nudify feature that is embedded in an app, website, or platform. So by simply uploading a non-explicit image of a person on vacation or in a family photo, anytime a person can click this feature and use a publicly available image to generate an image that portrays that person as naked, nude, or in a sexually compromised position. So why are we concerned about this? The victim pool is continuously expanding, and so does the advancement of this technology. I emailed all of the members on this committee 3 reports from a globally recognized organization called the Internet Watch Foundation, or IWF, and I included their newest 2026 report. IWF's internationally recognized work focuses on stopping sexual abuse online. And I want to specifically direct your attention to page 12 when you get a chance of the October 2023 report, where IWF lines up some of the non-sexual images that depict just how rapidly this photo generation technology has advanced just between February of 22 and May of 23. And 3 years later, videos, images, and more generated by AI are even more realistic and can be very difficult to clock. Many people cannot tell the difference at all. The technology advancement is not the only rapid escalation. The violent nature of the materials created using this technology and the predators' responses to them are also escalating. So when this content escalates in the AI world, it escalates in the physical world too. IWF reports that there has been a 26,000% increase in AI CSAM from 24 to 25, and these increases are skyrocketing more every month. So we know that these features can be turned off or removed because many companies who are in control of high-quality AI generative technology have already restricted this feature from their platforms. Reputable companies like Meta, ChatGPT, Adobe, Canva, and other platforms will not nudify an image if it is asked to do so. So why do we need to act now? Nudified AI-generated content today is the worst it will ever be, meaning that it will only get more and more pervasive and realistic with each passing day. The misuse of this technology has harmed too many people. It has empowered and enabled pedophiles and sexual predators to increasingly profit while causing more and more harm around the globe, particularly to children, and 90% of the victims of the child abuse that happens are little girls. These apps are really readily available in nearly every app store, and we should not leave this dangerous tool to be weaponized by more and more predators and leave it accessible to kids who don't know what they're dealing with. Members, we are already arriving at this work too late, and we cannot afford to wait any longer. And with that, Chair, I'll turn it over to my brave testifiers who will share a story with you
All
today.
right, thank you so much. And I just, we are in an extremely tight agenda today.
Chair, they're at
and-
2 minutes. They've practiced. They're really great.
Okay, and okay, very good. Jessica
Gusteles.
Welcome to the committee. Please say your name for us and go ahead.
Thank you. My name is Jessica Gusteles, and I am here as a direct victim of Nudification technology and as a voice for over 80 other women that we know of harmed by a single person using a single tool. In June 2024, a man I trusted for over 20 years, a former roommate, someone I considered a close friend, used a family photo from my private Facebook account to create multiple pornographic videos and images of me. Not just one, but multiple. And not just of me, but of over 80 other women. I cannot overstate the harm this technology has caused. Every woman who called the police was told some version of the same thing. We don't know what to do with that, and they weren't wrong. There was nothing they could do. The damage to me personally has been lasting. Beyond the immediate trauma, what people may not understand is this violation does not stay in the past. It follows me. I had to tell my HR department what happened, and anytime I will apply for a new job, I will have to tell someone again. Not because I choose to, but because I don't know where those images are or who has seen them. I am re-victimized every single time I have to say those words in a public setting, professional setting. And because I am a public professional, I am published in articles, webinars, and I have public speaking engagements. My image remains permanently accessible for this kind of abuse. This perpetrator's single act has given itself an indefinite sentence over my career and my dignity. It doesn't just live in my career, though, it lives in my body. Shortly after learning of this violation, I attended a conference that I was invited to speak at. Day one, in a room full of women supporting women, this is a women and women room, a supposed safe place, a camera shutter clicked. I'm sure it was for the conference website, but in that moment, I was not just in that room. I was sent to the very darkest corners of the internet. I'd seen these images. I was also ended up back in my room with a panic attack. That is what this technology does. It doesn't just live on a screen. It follows you into every room, every job, every moment of vulnerability. The internet is forever. The damage is irreversible. Please vote to move this forward and take this weapon off the table. Thank you.
Thank you very much. Very sorry to hear of that, and thank you for sharing it. Molly Kelly, welcome.
Members of the committee, my name is Molly Kelly. Thank you for the opportunity to testify. The man who targeted me was the same as Jessica, and my husband's best friend of 20 years. When this happened, I was 6 months pregnant. The stress was significant and had a significant impact on my health. My doctors were concerned. I stopped going to work in person. Every mundane work event felt suspicious. I didn't know where the images were or videos. I spent my maternity leave finding the resolve to speak publicly about this issue. When I realized how this technology was being used, I removed every trace of my children from the internet. But personal choice is an illusion. We tell parents to be careful, post less, monitor more, lock things down, but none of that can reach the phone in someone else's hand. There is no expectation of privacy in public. Any child on a playground or school can be turned into a target in seconds. This is not a problem that can be solved by telling families to try harder. Individual caution cannot compete with an automated abuse. This technology is used overwhelmingly against women and children. It creates a real barrier to participation in public life. Jessica and I and countless others are forced to live with the consequences of intimate acts that never happened. For children, the harm these images create a permanent record of humiliation before they're old enough to understand what's been done to them. Allowing tech companies to hide behind Section 230 in the First Amendment is a moral failing. They are making, using, selling, and profiting from abuse. A 12-year-old can take a photo of a classmate and generate a pornographic image in less time than it takes to walk between classes. There's no delay, no barrier, no meaningful safeguard. That same child is far less likely to acquire the skill, time, and resources to do the same thing without such a tool. So if this body wants to reduce the harm, it has to address the mechanism producing it. And this is what the bill aims to do. Technology can do remarkable things, but it can also be used to degrade, exploit, and intimidate. I recently read that kids don't dance at school events anymore because they're afraid of being filmed and mocked. Phones aren't going anywhere. Some downsides are here to stay, but we can stop children from having their likeness used for sexual abuse before they can even read. This is a straightforward, compelling government interest. I urge you to vote yes.
Thank you.
Thank
Thank you very much. Yeah, perfect, perfect. And thank you very much for both of you again for sharing your stories. And I know that it is re-victimizing to have to come and talk about these things, and really appreciate your doing so. And then we have Sandy Johnson on Zoom.
Thank you, Madam Chair, members of the committee. My name is Sandy Johnson. I am the Senior Legislative Policy Counsel with RAIN. RAIN is the nation's largest anti-sexual violence organization, and we also run the National Sexual Violence Hotline. I want to thank the members of this committee for listening to these survivors' experiences. And what I would like to say is they are not alone. As the National Sexual Violence Hotline, we hear stories about this tech-enabled sexual abuse every day from survivors. And what is important to remember is that this harm happens the second these images are created. In a recent incident, 190 images were being created a minute. So every minute that these images are up, it's causing harm. And to remove these images takes years if they're ever able to do it. So RAIN supports this legislation, and we urge you to move it on to the General Assembly. Thank you.
Thank you for your testimony. So we have no further testifiers. There is another amendment, and then so Chair Scott.
Thank you, Madam Chair, and thank you, Representative Hanson, for bringing this bill. There's so many dangers out there. Thank you for to the testifiers as well. So what this bill would do, or what this amendment would do, is give a right to cure, just 10 days to cure, since this is new legislation, just 10 days for anyone who might have this dangerous tool to cure the situation and take it down. And while I think it's a reasonable effort, I did talk to both the author and Representative Bahner on why this may not work into the bill. And so with that, I will withdraw it, and I appreciate what you're doing here. And that's it, Madam Chair.
All right, thank you. Thank you, Chair Scott. And is there any member discussion? Representative Engen.
Thank you, Madam Chair. I'll be super brief. Thank you so much for sharing your guys' stories. I know how much, I mean, this is disgusting. It's just making me sick to my stomach. I don't know what you guys are going through, but I know that you've worked alongside Representative Hanson to form something that's going to make sure others don't have to do or go through what you've had to go through. So I want to thank you for that. I want to share this stat. There was 4,700 cases of this in 2023. There were 400,000 in the first half of last year alone. Yep. I mean, that is incredible. That is, it's such a staggering increase. Over 8,000 of those were child sexual abuse material cases. So anything that we can do to get ahead of this, because we've talked several times about how AI and our data and technology being on the rapid increase that it is, we're always playing catch up. We're always the dog that's chasing its own tail and trying to retroactively put the genie back in the bottle or the toothpaste back in the tube. We don't have to do that with this one. We can get ahead of it. We can put this to an end, and we can stop the harm that it's caused. So thank you so much for your guys' work. I'm a yes all the way through.
Thank you. Representative Feist.
Thank you, Madam Chair. I was just noticing that, or thinking about the fact that we're regulating people who do this, and I wish we could also regulate the companies that create these tools, because they are also monsters, in my opinion. I did have a technical question on line 2.17, when we talk about each unlawful access, download, or use under subdivision 2. I was just thinking, is that like every time somebody accesses the image that the person posted, which I would be fine with? So like if it's like $500,000, if something goes viral, then we can really punish people who do this. And I just wanted to get clarity on that.
Representative Hanson.
Thank you, Chair, and thank you for the question. So this goes after the feature of technology. So I want to be really clear, and I think I saw the conversation just there, right? So it goes after the feature of the technology, and we can certainly ask nonpartisan if they want to comment on it too. But yes, you are correct that it is in each kind of the impact of it. It's whoever offered that feature, then each view or posting or whichever after that is where it goes. That's the harm that perpetuates the problem. But let's be clear, creation is the issue. When we have apps that allow that to happen, that's where the problem starts. That's the seed. And if we can get to the seed, we can get to the rest of it.
Representative Feist.
Yes, so just to confirm, I understand, and I think you just said it, but I was also distracted as I was getting clarification on my own question. So person does include the corporations that create the technology. Perfect, thank you.
Yeah, and maybe Ms. Davis, did you want to comment?
Sure. Yes. Chair and members, Mary Davis from House Research. The penalties that the Attorney General can enforce under this section are directed at the software, the app, the company that owns those pieces of software, that application. And so it's an unlawful access, download, or use for that fine. So each time, you're probably going to have a product to see that that was done, so they've made something, and then that would, each time that happens, they would be fined.
All right, thank you. All right, seeing no further discussion, just, oh, is there more? Representative Hudson.
Thank you, Madam Chair. I'll be quick. First of all, as everyone has said, thank you for bringing the bill, and thank your testifiers for being willing to share their horrific story. I do have a peripheral kind of legislative practice concern with the provision in 219 through 3.5, whereby the funds that are received from these civil penalties would then be redirected to grants to nonprofits and administrative costs for the agency. This is something we do around here, and I just wanted to flag it as something that has a concern for me personally in terms of furthering the degree to which we're funneling money to nonprofit organizations and increasing the potential for issues that we've seen in that area. That's not a good reason to oppose this bill, and so I definitely support the bill, but I just wanted to flag that for potential discussion as it goes to the floor.
Okay, thank you, and maybe those kind of discussions can continue. Representative Moller.
Thanks. I'll do that offline. This is for an account that we created in public safety last year, and it all goes through the Office of Justice Programs. It's already an established account, and they did really well when they had an OLA report, so I'm glad to talk to you about that as well. But seeing it in here looks a little different than what we've done in public safety, so thanks.
All right, final word, Representative Hanson.
Thank you, Chair, and thank you, members. I know it's deadline week and lots of things are really busy, and getting this bill here is really important to me. And I do believe the motion was to go to the general register, I believe.
That's
and
correct.
Thank you for the head nod. I see that. And so thank you for that. I just think it's really important. There's a headline out there if you Google it, and I should have brought you a copy, but it says, "The AI child exploitation crisis is here." And within that article, you're going to see references to, in just a month's time, there were 500,000 crimes that were detected, but there were not 500,000 arrests. And for that reason, that's why I think it's really important we get to the technology that's creating that. 64% of the latest crimes were found to be Class A, which is the most violent material out there, right? We can get ahead of this curve, as Representative Engen said, and it would really be a shining star for the North Star State to lead on this. So thank you so much for your support, and please sign on to my bill if you support it. Thank you.
Thank you. Thank you for bringing the bill, Representative Hanson. Thank you again.
Chair, can I mention one more thing? Representative Bahner has been critical in working on this. She helped Representative Scott do this, and I did not offer to give her a chance to say something, and I would leave it to the chair's discretion.
Yeah, no, I think we need to move on, but thank you, and I know her involvement has been tremendous.
And she promises to speak on the
Thank
floor.
you very much. So,
sounds good.
Okay, so with that, the chair renews the motion that House File 1606, have I got the right one? Yep, 1606, the first engrossment as amended, be placed on the general register. All in favor, please say aye. Aye. Any opposed? Motion prevails, and we are moving the bill. Thank you. Okay, we have Representative Huot, House File 3356, and so the chair will move that House File 3356 be re-referred to Ways and Means. And there is an amendment, the A4, that I understand is an author's amendment. Representative Huot? you have the A4.
Yes, Chair Liebling, the A4 is my amendment. It's one of the many amendments to this bill, but this hopefully gets the shape that a number of your committee members wanted to see it in.
Okay, very good. So, so I will move the A4 amendment. Is there any discussion to the A4 before we adopt it? Seeing none, all in favor, please say aye. Any opposed? Motion prevails. The amendment is adopted to your bill as amended.
Thank you, Chair Liebling. Thank you, members, for hearing this. I'll make this quick. We've had many stops with this bill. This bill basically puts some limits into what we would better call posers, people trying to be police officers. This is one small step that we can actually control this at the state level of putting a civil penalty on mostly dealers, because most of our municipalities do this already. It's just basically taking all the emergency or anything that identifies a squad car only. We're not talking ambulance or fire trucks, but a squad car from possibly being identified as a active police officer's car. This was inspired by the June 14th situation. However, I've been looking at this since I've actually been in the House. This has been going on around the country. We hear terrible situations of posers as police officers pulling over people and doing bad things. I just got an email last week about somebody taking a squad into an area that was basically set up for a police area, and somehow they were able to drive right in because they had basically what they said was a police car. So I want to go quickly here with it, but I welcome any questions. There are no testifiers.
All right, thank you very much, Representative Huot. So there are no testifiers on the bill. We will go to member discussion. Is there any? Representative Steer.
Thank you, Madam Chair. So my question is, I don't think that this bill is going to stop people from impersonating a police officer. And local agencies mostly do take all their equipment out of their cars. It's the agencies that simply cut the wires, pull out the control box, but leave the lights inside the car to sell. The lights are essentially worthless. They don't work without the control box. So I think it's going to impact those smaller agencies that can't afford to send it in and get everything stripped. And even if they are stripped, the back of the car still says Ford Police Interceptor. That's how they sell them. And then it goes to a dealership, and somebody can go on Amazon for $100 and put a red and white blue kit in their car in about 20 minutes. So I don't think that this is the right path for this bill. It's a good idea. We're already doing it. But if they're going to impersonate a police officer, they're going to find a way to do it.
Representative Hewitt.
Madam Chair and Representative Steer, we had great conversations about this bill and where the money goes when they sell these police vehicles. I believe it was your agency that uses the proceeds from a sale to outfit their next car. I really appreciate that insight you gave me over this, and I was hoping we can get to neutral on this with you. However, this is one little step. This goes much further than this. As you know, as a police officer yourself, we have people that get lights for their vehicles. They have illegal lighting. I wanted to attack this here, but this is the first step. I'm hoping that our people that have served in law enforcement in emergency status can help me when we go after lights, because that's a whole big mess. But this is one step towards it. You're right. No one, any of these bills that we do is never going to stop anyone, right? But we can't turn our back on the small part, and this is really small. That's why I asked for your vote today.
All right, thank you, Representative Hewitt. I don't see any other member discussion, so we will in a moment move to the vote. But I just would say that, you know, we just heard a bill about a huge problem that we're all like, you know, just I think around this table we're just appalled at what's going on, and we know that passing a bill doesn't fix everything, and yet we do it. And we're always in that situation, and so because of that, of course there's another bill moving about impersonation of a police officer to tighten up on that as well. So I appreciate your efforts on this, Representative Hewitt, and the thought of being stopped on the highway by somebody impersonating a police officer is just horrifying. And if we can do anything to try to cut that down, I think that it's worth doing. So I will renew the motion that House File 3356, the second engrossment as amended, be re-referred to Ways and Means. All in favor of the motion, please say aye. Aye. Any opposed? The motion prevails. Thank you. Next on the agenda, we have Representative Moller, 3946, and Representative Moller's motion will be to move that House File 3946 be re-referred to Ways and Means. And there is an A6 amendment that I think is the author's amendment. And Representative Moller, did you want to take that up first, or do you want to first explain your bill?
Yeah, Madam Chair, I think the A6 amendment is what's in this committee's jurisdiction, so if we can just adopt it, and then I can go through that
Okay.
at that point, that would be great.
Very good. Okay, so Representative Moller is moving the A6. Is there any discussion to that? Representative Steer?
Yeah, thank you, Madam Chair. Just in there on line 2.7, what is the definition of officer in charge? That's a new thing for me in statute.
Representative Moller?
Thank you, Madam Chair. That's already in the current statute, so we're just amending other aspects of the statute. So I don't know, that didn't come up in public safety, and it's not part of this actual amendment because it's in the current law. So if it's possible, if we can just adopt the amendment, and then maybe council can look that question up while come back to it.
Representative Steer, we could ask House
I think
Research to.
So 2.2 is in determining if a person poses a threat to alleged victim, then it mentions the officer in charge and the police station or the county sheriff in charge or the jail. Those are all new. Well, they're underlined in your A2. Isn't that new, or?
Well, if you're looking at the A6 amendment, Representative Steer, on line 2.7, where it says the officer in charge of the police station or the county sheriff, that is not underlined, so that's not new language.
How about 214?
214, it does use that language, 214.
Right, Madam Chair, it does because it's already in statute, so maybe staff at this point has an opportunity to weigh in on that.
Mr. Johnson?
Madam Chair, members, I don't have a lot to add. This is currently in law, has been in law for some time, where it refers to the officer who's in charge of the police station or the county sheriff in charge of the jail. That's the current law. Those are the individuals who are empowered in these arrests to decide if the person will be held in custody or released based on a citation. The new language repeats that because it's clarifying when that person has this authority and when this person must hold the person to be seen in front of a judge. That clarification is also consistent with other parts of law, but those other parts of law are often missed because they're sort of buried in the harassment restraining order and the domestic abuse no contact order statutes. They are not defined terms, but that means if there's any question about it, the court would have to look at the plain meaning and would have to determine who is in charge of the police station and who is in charge of the county jail. Presumably, that would be the chief law enforcement officer of each of those situations.
Okay, anything further, Representative Steer?
Well, then it goes on to say that the person has to be held into custody and then they can be released in lieu of with a citation. So we're dealing with a felony situation, and then it's up to the officer in charge or the sheriff in charge of the jail to release the person with a citation, but it also says that they should be held. So I'm confused on what we're trying to, are they going to be held, or are they going to be released with a formal complaint? Or we don't write citations for felonies, but this is confusing.
Representative Moller?
Thank you, Madam Chair. Well, I'm not sure which, so lines 2.4 to 2.7 are specific to violations of orders for protection and orders for domestic abuse no contact order. Those are actually referred to in the other statutes referenced here, where somebody needs to be held until they see a judge. And so what we're trying to do with this amendment is all the other domestic violence situations that don't involve those two things. Under current law, there's the opportunity to release somebody under paragraphs 1 or numbers 1, 2, and 3 on lines 2.10 to 2.12. We're just adding in factors that should be considered when law enforcement is looking at what's already in current law in on lines 2.10 to 2.12. So if your confusion is about the reference to the DANCOs and the violations for orders for protection, we're actually adding clarity because the statutes currently don't, they're all, they conflict with each other currently. And so we're adding clarity that those other statutes apply in those situations.
Representative Steer?
It's still confusing, but whatever.
Okay, well, if we adopt the amendment, we can continue to discuss the issue to the bill as amended. So any other discussion to the A6? Seeing none, all in favor of adoption of the A6, please say aye.
Aye.
Any opposed? Motion prevails. The A6 is adopted. To the bill as amended.
Thank you, Madam Chair. So there have been many intimate partner homicides, I mean, certainly over the years, but it feels like we're seeing an increase in number of victims in those cases. And I've also seen in my own experience as a prosecutor and talking to victims and survivors and advocates that there really has been a lot of system failures when it comes to domestic violence. And in fact, my testifier here, the system failed her family. And we were at an event together and I heard her speak. And it was really what prompted me to decide, let's take a hard look at these statutes and see what we can do to fix these systems. And I'll note that even after this bill was introduced, there have been many other intimate partner homicides where the victim had done what we ask of victims to do, reporting it, getting orders for protection, et cetera. And the system failed those victims, particularly one in International Falls recently where when the victim was released, the judge apparently didn't look at the order for protection and what the victim had said in the petition about escalating violence. And so this isn't any one particular part of the system. It's really the whole system that needs to be reviewed. And so what we've done with the bill is try to create a comprehensive approach and then also create a task force, which is in the public safety's jurisdiction. I can go through just briefly what the amendment does, which we've discussed already. The first section 4 has to do with gone on arrival cases. Right now in misdemeanor domestic violence cases, there's a 72-hour period where the arrest has to happen. We're hearing from lots of victims that that time period is just too short. So we've changed it to 28 days here. I will note that the private defense lawyers have a concern that 28 is too long, so we'll continue those discussions with them. In addition, we already talked about the, and then lines 1.11 to 1.17 of the amendment has to do with law enforcement seeking an arrest warrant during that time period. Because once an arrest warrant is there, it's my understanding, talking to Representative Steer and others, that it's better on the system, that the computer system that law enforcement has, that'll flag that case more than the cops alert that goes with just that other time period. We already talked about some of what we're trying to do with lines 2.1 to 2.21. And then as far as the judicial review provisions, this is also mimicking those factors that we ask law enforcement to consider in a release, for also judges to consider when they're making their decisions about release and bail conditions. One other important piece here in this amendment is line 3.4, and that's using the electronic filing system to allow prosecutors to provide all the information that they have about the offender to the court to make those determinations. It's my understanding now that some jurisdictions will accept those electronic filings and others will not. And we did confirm with the courts that this would not have an added cost because it's using a system that already exists. And with that, I'll turn it over to my testifier.
All right, thank you. Welcome to the committee, and please introduce yourself in just 2 minutes, please.
Thank you, Madam Chair and members of the House Judiciary Committee. Thank you for allowing me to be here today. My name's Jana Williams. 2 weeks ago, I told you about Allison Lucier beaten to death by her partner and that 72-hour state statute that gave room for interpretation that failed her. Tuesday, February 13th, 2024, 6:30 p.m., Allison let her abuser into her apartment. He began beating her and strangling her, stripping her of her clothing. She ran to her neighbors next door just in her bra and her underwear. They called 911, and when the police showed up, her abuser was GOA. They told her to call them when he comes back, if he comes back, and they will come back and they'll arrest him, but she only had until midnight on Friday to do so. As they stated the 72-hour state statute, Friday, a little after midnight, Allison arrived home. She knew it was her abuser. She went to another neighbor's where she called 911, and the same 2 officers who arrived on Tuesday came on Friday. So they knew that her abuser had done what he had done to her 3 days prior to that. They found him in her apartment, but they let the abuser go because it was 32 minutes past that 72-hour state statute that allows officers to make a probable cause arrest on an abuser. I had the privilege to watch the body camera of those officers stating the statute and why they couldn't arrest him. I'm back here today to ask you how many more. Since I last spoke, I learned that my 18-year-old niece, Ariana Buckanaga, who was murdered in a drive-by shooting, finally had a suspect charged. 6 years later, 6 years of waiting, 6 years of wondering if justice would ever come. And just sitting here today, I received notice that the audit into Allison's case brought forth by the Minneapolis City Council, triggered by clear failures, will be released April 16th. Let me be clear, an audit does not save the next victim. A report does not prevent the next death. Changing the law does. So I ask you, if this were your daughter, if this were your niece, your family, would you accept this system? Would you accept delay, failure, and loopholes? Or would you demand change? Because families like mine shouldn't have to fight this hard just to be heard. I am asking you to act for those this law has already failed, and for those that it will fail next if nothing changes. This is not optional. Protecting the most vulnerable is not a privilege, but protecting the most vulnerable is our duty. It is now the time to do it. For Allison, for Mariah Samuels, and for all victims of domestic violence that are begging for your help through our voices. Now is the time. Miigwech.
Thank you. Thank you for your testimony. Okay, so there are no further testifiers. Is there any further member discussion? Representative Steer.
Yeah. Thank you, Madam Chair. I just want to say, for the record, I'm all for this bill. I do support the bill 100%. The officer in charge part is throwing me off a little bit. That tells me that in a smaller agency, the guy that just started, that's on his own, working the road, he's in charge. At that point in time, he's in charge. So he's going to make a decision based on whether we're going to release this person or not. I don't like the language. I get it. If there's a way to change it down the road, that'd be great. And then it's just in lieu of a citation. I should have caught it in public safety, you're right. But that part doesn't make sense to me, that we're gonna let them go and issue them a citation. We have some reasons not to let them go in this bill, but we're gonna issue them a citation and say, don't come back. I mean, that liability falls now on whoever just gave them the citation and sent them out. If anything happens, that person is liable, rather than the courts. So I just have a little heartburn.
Thank you. Representative Finke.
Thank you, Madam Chair. Appreciate your bill, Representative Moller. I just want to say, intimate partner violence, the most common form of violence on earth. Domestic abusers are the most likely murderers that we have on earth. We know that this is a problem. We know that this is something that needs to be tightened up. We need to protect people. And thank you for coming to share your story. Thank you for this work.
Thank you. Okay, final words, Representative Moller.
Thank you, Madam Chair, and certainly Representative Steer, I'll continue to work with you on this. I think maybe some of the things giving you heartburn are what are already in statute. And so if there are ways, we can certainly work on trying to clarify that before this goes to a floor vote. But other than that, I hope members can support this. Thank you.
All right.
And Madam Chair, was your motion to send it to Ways and Means?
Yes.
Okay, great.
All right, so Representative Moller renews her motion that House File 3946, the first engrossment as amended, be re-referred to Ways and Means. All those in favor, please say aye. Aye. Any opposed? Motion prevails, and it's on its way. Thank you. And Representative Moller is going to stay there because we have House File 3970. And the motion, Representative Moller's motion on House File 3970 is that it be re-referred to the General Register. And there is a DE2 amendment. And Representative Moller, do you want us to just adopt that so we can discuss it? Or do you want to explain it first?
Thank you, Madam Chair. That would be great since it's a DE.
All right, so she will move the DE2 amendment to put it in the order in which she would like to discuss it. Is there any discussion to the DE2? Seeing none, all in favor of adoption of the DE2 amendment, please say aye. Aye. Any opposed? Motion prevails. The DE2 is adopted. To your bill as amended.
Thank you, Madam Chair and members. This bill fills another gap in existing law that is needed to protect victims of domestic violence, sexual assault, and other forms of domestic abuse. Domestic violence advocates have seen situations where the survivor and abuser are co-purchasers in a contract for deed, and the abuser abandons the property and stops making any contributing payments on the contract. And this leaves the survivor who's able to make those payments, wants to remain as an equitable owner in the home, in the predicament of having to share an interest in the property forever with a person who's committed these acts of violence and is not bearing any responsibility for the payments, insurance, tax, maintenance, et cetera, of the home. Currently, there's no viable legal remedy that can extricate the survivor from this situation. So under this bill, a survivor is granted the right to petition the court to terminate the abuser's interest in the contract for deed if the survivor proves a number of things by preponderance of evidence. And of course, there's a due process for the person whose potential property rights are being terminated. That's also built into the bill. I want to thank Standpoint and Legal Aid for bringing this issue to my attention and really working with a number of stakeholders, including the Real Property section of the Bar Association. The Minnesota Indian Affairs Council provided their input as well, and then Minnesota Title Association, Bankers Association, Credit Union Network, and Retailers Association. And there's no known opposition to this bill, and I do have folks here to answer questions if you have them.
All right, thank you. Is there any member questions? Or member discussion? So we have no testifier signed up to testify, I should say. So we are moving to member discussion. And I'm not seeing any. So any closing comment, Representative Moller?
Thanks for your consideration.
All right, so Representative Moller renews the motion that House File 3970 as amended be placed, it's going to the general register, be placed on the general register. All in favor, please say aye.
Aye.
Any opposed? Motion prevails. The bill is on its way to the general register.
Thanks.
Representative Frazier's bill is up next, House File 3658. And Representative Frazier is going to move that House File 3658 be placed on the general register. And there is an amendment, but I don't think that's an author's amendment. That will come later, I think, correct?
Madam.
Representative Frazier, so the A3 is not your amendment, correct?
It is not my amendment, Madam
All
Chair,
right,
but
so let's go ahead with your presentation of the bill, and then we'll get to the amendment.
Madam Chair, I mean, this may be out of process or normal action, but it is not my amendment, but it is a friendly amendment. So I am open to addressing the amendment now and then allowing Mr. Diebel to walk through the changes for members to hear unified.
Okay, well, that's fine with me. This is Representative Steer. Did you want to offer the amendment?
I will offer the amendment if Nathan, Hopkins can take care of it.
Okay, so you're offering the A3, and Mr. Diebel is going to walk through it.
Thank you. Good morning, Madam Chair and members. The A3 amendment addresses three issues in the bill. The first is on lines 1.2 through 1.5, and this would allow for law enforcement agencies who are serving an ERPO on a respondent. When they have a search warrant with them, they would be allowed to execute that search warrant and take possession of the respondent's firearms as the court has directed them to do. Currently, there's some conflict in the statute about the respondent having 24 hours to dispossess themselves of their firearms, and this would resolve that conflict when law enforcement already has a search warrant from the court indicating that they're in immediate danger and that the weapons need to be seized. The next change item is on 1.6 through 1.10. This would allow for a limited immunity for a respondent who surrenders their firearms voluntarily. So when law enforcement does come to the respondent's door and asks with a search warrant and they ask for voluntary compliance, if the person does so, they would be immune for prosecution for unlawful possession of those firearms. Just the limited under statute 624.713, that would not extend immunity to them if they had used those firearms in a different crime. It would just be for the offense of being an unlawful person in possession, but not, so that's why it's limited immunity. It's not blanket immunity. And then the final change is a clarification. Under the current statute, the respondent is entitled to sell their firearms if they wanted to dispose of them, but this would just make it clear that if law enforcement has the firearms, that the respondent can request that they be transferred to a third party who then could give the money, and that would comply with the existing protocol. So it would be overseen by the law enforcement and perhaps an FFL to make sure that the person is entitled to receive the firearms, but that they could receive compensation. And this would relieve law enforcement of perhaps having to buy as many firearms compensate the person for surrendering their firearms permanently. That covers the amendment.
All right, thank you. Is there member discussion to the amendment? And I do have a question, if nobody else does, about the amendment. Mr. Diebel, so just on this issue of having a search warrant and then also having the immunity piece, I just want to understand how those two things work together. I'm really fine with the immunity piece, I'm fine with the search warrant, but if an officer comes to the door with a search warrant, it's only if the person says, yes, and I have these firearms I'm supposed to turn in, that they get the immunity? What if I mean, I just need clarification there, because, you know, if they're coming with a search warrant, it almost by definition isn't voluntary.
Yeah, Madam Chair. So the protocol now is that the petitioner, whether it's law enforcement or a county or city attorney or a family member, goes to a court and they convince the court that the person's in immediate danger to either themselves or someone else, then the court can issue a search warrant for directing law enforcement to take immediate possession of the firearms. And so in those cases, rather than making it confrontational, I believe law enforcement would like to allow them to voluntarily comply with the search warrant. They would say, here, through your order, you've been ordered to dispossess yourself of these firearms, and we are going to give you an opportunity to voluntarily transfer them over. If you do so, you will have immunity from, and I think the hope is that this would give them some peace of mind that if they did have some firearms disability, that they wouldn't feel like they were now subjecting themselves to further prosecution for having that gun, whether it was however they came into possession of it.
Yeah, thank you, thank you. Okay, with that then, any other discussion on the A3? So all in favor of adoption of the A3 amendment, please say aye. Any opposed? Motion prevails, the amendment is adopted. So to your bill as amended, Representative Frazier.
Thank you, Madam Chair, and thank you, Representative Steer. Also, thank you, Representative Hudson. You did send an email right afterwards during the discussion in public safety with your issues, and I believe we addressed those, so thank you for that. Representative Steer, we've been in communication throughout during this process, so thank you for what you did and helping to get to this point and looking forward to moving forward. You know, at the core, this is legislation that has saved many lives and prevented many tragedies. What you're seeing with these modifications is not a change of direction from what we're doing, but it is making this bill stronger so that we can save more lives and we can continue to use a useful tool that law enforcement has found useful, that communities have found useful, and that the courts have been exercising their ability to make determination and grant these petitions when needed. Madam Chair, with that, I will allow Mr. Diebel to, if we need to, we've had a pretty robust conversation in public safety, but I'll allow Mr. Diebel to walk through what the modifications do, and then I would ask for support of this bill to move forward.
All right, well, thank you, Representative Frazier. I don't know if that's really necessary. Do members feel like a walkthrough is necessary? I don't think we need that. So is there any, there are no further testifiers. Is there any member discussion to the bill as amended? Chair Scott.
Thank you, Madam Chair, and thank you, Representative Frazier. I'm just wondering on 5.2526 why the service to the individual is being, I'm assuming it's in person right now, is the way that it is right now, and why are we changing it to that it could be served electronically or by first-class mail?
Representative Frazier.
Thank you, Madam Chair. Thank you, Representative Scott, for that Chair Scott, for that question. This was asked for by practitioners as a way to limit the number of interactions that have to happen between individuals that are receiving this particular order, and this was to address that issue.
Chair Scott.
Thank you, Madam Chair. I'm just wondering why, like, at least it wouldn't be, certified mail or something. How are we going to know that this person opened their email or got their mail? Yeah, that's my concern with that piece. I think that's my only question at this moment. so.
Yeah, Representative Frazier.
Madam Chair Scott, we can absolutely make sure we tighten that up to clarify that, to address that issue.
Yeah, great. Any other discussion? Representative Duran.
Yes, I was actually wondering about kind of the same thing because I was a little concerned that actually might tip people off about the actions that may be coming in the future. So they may build up defense, or they may, hide things or hide their guns, or, if they don't want to give them up or whatever. So I'd be willing to kind of talk about that stuff and work that through as well. So.
Sounds good.
Thank you. Mr. Diebel?
Yep. Madam Chair and members, I would note that this is amending the section that refers to the situation where there's been a hearing and the respondent's been notified of the hearing. So it's not the case where there's an emergency ex parte order where they may not be present to hear that. That would be personally served. This would be a case where it'd be follow-up to what they should have known, unless they perhaps didn't appear after receiving notice of the hearing, but there would be a full hearing in this case. So it's limited to that section.
Thank you. Thank you for that. And yeah, I mean, I think we're all, want to be concerned too that when law enforcement, whatever law enforcement is doing, that their safety is paramount, right? Yeah. Anything further from members? Okay, seeing none. Representative Frazier, any final comment?
Madam Chair, this is a tool that data has shown has been able to prevent gun violence and prevent tragedies. I think we've done a great thing by providing this. I know we often get stuck in the conversation when we're talking about gun violence and how we address the root causes, but this is actually a tool that is actually saving lives, and I'm looking forward to moving this forward in a bipartisan way.
Very good. So Representative Frazier is going to renew his motion that House File 3658, the first engrossment as amended, be re-referred to the General Register. All in favor, please say aye. Aye. Any opposed? Motion prevails. The bill is on its way. The next bill on the calendar is my bill, and I'm just going to do that from here, if everybody's okay with that, just in the interest of time. So this is the Judiciary Policy Bill that we heard in the committee some time ago. And so I have an author's amendment to the bill, and it is the A5 amendment. So first of all, I'm going to move that House File 3875 be re-referred to the General Register. And then I'm going to move the A5 amendment to bring it before the committee, or to put it in the form in which I'd like to discuss it. So maybe I should kind of go through that before we adopt it. So the amendment deletes sections 1, 2, 3, and 4. So I'm sorry to the Judiciary, but we are deleting a lot of the bill that they brought forward. So we're deleting all the parts about collecting race and ethnicity data. We're getting rid of the binding arbitration portion. We are removing, and then we are going to, in the amendment, we make some changes to the newspaper publication piece of this, and I might ask House Research to explain that. And then the piece of the bill in the amendment, it's, let's see, starting on lines 2.14, the part about the effect of an order for restitution, which the Judiciary had asked us just to extend that and make it renewable in a more easy process. And if you remember, I asked Mr. Shorba, why can't we just have it not expire? It's an order for restitution. So that's what is happening in this amendment. And so there are some other parts of the Judiciary's policy bill that are remaining. And they are the notice to public authority piece about when children are not involved, and that piece has gone through the Children, Youth, and Families Committee. And also the, let's see, the report, extending the date of the report, also went to Children, Youth, and Families. So I don't know if I covered everything, but let's see, would that be, who's working on that? Mr. Johnson, did I miss anything there? And you could please explain that piece in here about the publication.
Madam Chair and members, first, I don't believe you missed anything, Chair Liebling. The two sections that you mentioned are to replace actually what you initially adopted in the A1 amendment when this was initially before the committee. So just procedurally, you'll probably need to withdraw, reconsider and withdraw the A1 to replace it. These provisions related to the notice requirement involving publication in a newspaper. The courts had moved some language that would have fully excluded them from putting the notices in the newspaper and instead allowed them to put it on the website. There were some technical questions that had been raised about the initial language. This is the replacement that the courts have proposed to address some of those technical concerns, and it does that. Of note, though, there is one difference to the language that the court had proposed, and that's on lines 18 through 20. This allows the courts to post those notices on their website, but only in the situations where the judicial branch determines that there's no qualified local newspaper that's likely to give notice. So if there is a qualified local newspaper, they would continue to need to put that notice in the newspaper.
All right, thank you very much, Mr. Johnson. So this was drafted to include a concern that Representative Van Binsbergen brought forward to just, you know, I think we all kind of share the concern that we don't want to cut out some of the local newspapers, small newspapers. They're having a tough time anyway, and we don't want to move their demise along with something that we're doing here. So, any discussion to the A5? Oh, and I guess we need to. Go ahead, please, and we'll withdraw the A1 later.
Thank you, Madam Chair. I was just going to say I'm in support, and we collaborated on this. It wasn't just your decision. So we did collaborate on it and feel like we have a good medium ground on some of these. Yep.
Yeah. Thank you, Chair Scott, and thank you very much for your partnership on this. So I think we have to withdraw. Oh, I'm sorry, Representative Van Binsbergen.
I just, thank you, Madam Chair. Just want to thank you for the A5. You know, I think that is really important. I come from a community of, I've got a lot of newspapers in my district that do rely, it's been a historical piece of their budget, and I'm just, that's an important piece that is going to continue, and that funding is going to continue for those local newspapers. A lot of these papers are family-owned businesses that rely on that. They rely on that, and again, as you said, these newspapers have had a really, really tough time in the last number of years, so thank you.
Thank you very much. And so I think we have to I would move to withdraw the A1 amendment, which was a different amendment that we put on in the last hearing that we're now replacing. So any discussion about that? So all in favor of withdrawing the A1 amendment? Is that the right motion, Mr. Johnson?
Madam Chair, members, that would be correct. This will clarify what the committee's doing. You'll be replacing that A1 that you adopted previously with this new language.
All right, so all in favor of withdrawing the A1 amendment, please say aye.
Aye.
Any opposed? So the A1 amendment is withdrawn, and then I will offer the A5, and any further discussion on the A5? So seeing none, all in favor of adoption of the A5 amendment, please say aye. Aye. Any opposed? Motion prevails, and the A5 is adopted. So there is a testifier from, let's see. Oh, okay, Lisa Schwartz. Welcome to the committee. If you could please state your name and be very brief if you can.
Thank you. I'll keep it very, very quick. My name is Lisa Schwartz. I am here on behalf of the Minnesota Newspaper Association and its more than 240 print and online members across the state. The Newspaper Association wishes to express its appreciation for the changes on the A5 amendment related to the notice publication. We believe the language that you've adopted in the amendment better serves the intent of the public notice laws, including in transparency and best reach for those notices. We'd like to thank the author, the committee, and the judicial branch for their work on this. And we'd also like to reiterate that we have and will continue to work with government agencies on public notice issues whenever challenges arise. So please don't hesitate to reach out for our input, and thank you very much for your work. We appreciate it.
All right, thank you for your testimony. Okay, with that, there being no further testifiers, is there any member discussion to the bill as amended? Seeing none, so I will renew my motion that House File 3875 as amended be placed on the general register. All those in favor, please say aye.
Aye.
Any opposed? Motion prevails, and the bill is on its way to the general register. Okay, we have arrived at the highlight of the day, the cat and dog bill. Puppies, kittens. Representative Norris, welcome to the committee. I will move that House File 2627 be placed on the general register, and there is an amendment to the bill, and let's see. And the A3 amendment, Representative Norris, did you want us to adopt that first, or do you want to describe it?
Chair Liebling, we can go ahead and adopt it first. It is, it just deletes the severability section of the bill. This was something that was done at the request of the Senate GOP on the Senate side, and we're simply doing it here on the House side in a spirit of bipartisan and bicameral cooperation.
All right, excellent. So I'm moving the A3. Is there any further discussion to the A3? Seeing none, all in favor of adoption of the A3, please say aye. Any opposed? The motion prevails. To-year bill as amended.
Thank you, Chair Liebling. Members of the committee, this is a bipartisan bill to protect consumers and prevent animal cruelty while keeping bad actors from coming into our state and avoiding shuttering anyone's business. For years, the pet store industry has trended away from selling live cats and dogs. Advocates have expressed concern about the welfare of animals sold through the few remaining stores that engage in this practice. This bill begins the process of ending these sales in our state by prohibiting any stores that don't currently sell dogs or cats from doing so. The version of the bill before you is the result of significant listening and compromise over the years. We've tried to respond to the primary concerns we've heard by grandfathering in existing businesses as long as there is transparency about where the animals are sourced from, allowing the grandfathered businesses to be sold or moved, and removing sourcing disclosure requirements from advertisements. This legislation takes a practical, balanced approach that allows existing pet stores to continue selling puppies while preventing any business model that depends on cruel puppy mills and consumer deception. It keeps bad actors out of the state while providing options for existing stores who are doing it the right way while also protecting animals and consumers. And with that, Chair Liebling, I don't believe we have any planned testifiers because we've been able to, I think, get everybody to a relatively good place on this bill.
All right, thank you very much. So I don't think anyone signed up to testify, so we will move on to member discussion. Is there any member discussion? Representative Finke.
Thank you, Madam Chair. And Representative Norris, I just want to thank you. I've been a supporter on this bill through the long journey of it, and I'm excited to see it succeeding. I appreciate all that you have done and those behind the bill. I think it's good work, so thank you.
All right, thank you. Any further discussion? Representative Van Binsbergen.
Thank you, Madam Chair. On the grandfathering clause, how many stores are grandfathered in currently, and what does that actually mean? So they're grandfathered in. Are they able to, can they sell their business someday? And can they sell their business someday? Is that I'd like to know how that works.
Representative Norris.
Chair Liebling, Representative Binsbergen, there are one, maybe two stores left in the state that I'm aware of that are selling live cats and dogs, and so they are grandfathered in. And then they do, based on some of the changes we've made in previous stops along the way, with that grandfather clause, they would be allowed to sell their business to another owner and still operate that particular business.
Representative Van Binsbergen.
And so is that other owner or that current party that's being grandfathered in, are they able to, can they expand their business? Is there limiting factors to how they can do business in the future?
Representative Norris.
Chair Liebling, Representative, the way that the grandfather clause is written is that it has to be a shop that sold or offered for sale an animal from the pet shop's physical premises for at least 1 year before the effective date of this section of the bill. So you would have to be a store that had been selling these live cats or dogs for a year prior to when this bill goes into effect.
And this bill has been through Commerce.
I know.
Yeah.
I know.
Okay, seeing no further discussion, I will renew the motion that House File 2627, the first engrossment as amended, be re-referred to the General Register. All in favor, please say aye. Aye. Any opposed? Motion prevails, and the bill is on its way. And Representative Norris is not on his way because he's here for House File 856. And is Representative Anderson also here? I know.
Yep,
Oh, good,
over there.
good. See, we outlasted taxes.
We did.
I thought that might happen. Okay. So the chair will move that Senate File 856 be re-referred to Ways and Means. And as a reminder, we're just going till 12:30. And there is an amendment. And Representative Norris, did you want to adopt the amendment before we discuss the bill?
Chair Liebling, on this one, I'll maybe do my introductory remarks and talk a little bit about the amendment in those remarks.
Okay, that's just fine, so please go ahead.
Thank you, Chair Liebling and members of the committee. Today marks another important step in our goal of crafting a bipartisan OIG bill that will make sure that this office is ready to do the work that Minnesotans expect it to do on day one. This work requires diligence and intentionality. The bill before you today incorporates several important changes from the version that passed the Senate. And the author's amendment I'm bringing forward today makes other critical changes recommended by the Office of the Legislative Auditor, including several that were in the original author's amendment I offered at the start of session. The amendment aims to avoid duplication of responsibilities between the OIG and the OLA and prevent unintended impacts on the work of the OLA. It also fixes the language that several members objected to in state government by making clear that the OIG is subject to the laws we pass as the legislature. Just as I indicated in state government earlier this week, I do not view this bill as a finished product yet. There is still more work to do. But we've been able to collaborate in bipartisan fashion to overcome many hurdles with this bill so far, and I'm confident we can continue to do so. That's why I'm pleased to have my colleague Representative Anderson here to co-present the bill with me. I want to credit Representative Anderson for her work on previous iterations of the OIG bill in the House and look forward to continued work with her to deliver on our shared goal of fighting fraud in Minnesota.
All right, thank you very much, Representative Norris. And Representative Anderson, did you want to make an opening comment?
No.
No, okay, all right. And I don't think we have any testifiers on the bill, so we can go to member discussion. Is there? Oh, we have the amendment, of course, we have the amendment. So, all right, well, let's then work on the amendment, and then we'll go to member discussion. So the A3 is before us. I will move the A13 amendment. Yes, it is last bill on the right before deadlines.
That's all right.
I'll move the A13 amendment to get it before the committee. So Representative Norris, did you want to then address that and maybe walk through it or ask staff to walk through it?
Chair Liebling, I provided some high-level overview in my introduction. If members have additional questions, I can certainly field those, or nonpartisan staff can as well.
Okay, so it is my understanding that the Office of the Legislative Auditor this was the amendment that they asked for, essentially, to make the bill work with their office.
That is
right?
correct, Chair Liebling.
Okay, is there discussion to the amendment? Chair Scott.
Thank you, Madam Chair. I think it's an important amendment, and I thank Ms. Randall, the legislative auditor, for meeting with so many so many of us and sharing her concerns. The last thing we need is to create an OI, Office of the Inspector General, and then it overlaps with what the legislative auditor is doing. We just want to have that kind of make more of a bright line between what the two functions of those offices are. So thank you.
Yeah, thank you, Chair Scott. And I think, too, that having this amendment come forward in Judiciary and having had the opportunity for the Office of the Legislative Auditor to really review the bill and let us know about these issues is, just because there's been so much attention to this particular bill, I think it's important to highlight that this is part of what the legislative process is for, that we all have eyes on the bill, that many of us do through the committee process, that we have an opportunity with a very important bill like this that has the potential to do wonderful things for the state, but also the potential to make it harder for us to function and harder for us to do the very things we want to do with the bill if we don't do it right. So I think it's, I appreciate Ms. Randall weighing in and her attention to this and everybody's assistance in making sure that this comes out to be the best possible product. Any other member discussion to this? Oh, and Representative Anderson, please.
Thank you, Chair Liebling. I want to put the things in here are very clarifying things. The legislative auditor has been involved since we started this process last year, but these are her last final requests of clarifying, so it's absolutely crystal clear, and we support this. We started our working group again, bipartisan, bicameral with the Senate, this about a month ago. The members of the working group have reviewed this and were involved in this, and they also support this. So this is something that the Senate also supports. So thank you.
Great. Well, thank you. It's great to see everybody working together. So seeing no further discussion, all in favor of adoption of the, oh, I'm sorry, Representative Steer.
Thank you, Madam Chair. Sorry, I don't want to put the cart in front of the horse, but AG Ellison is looking to get some extra people in the Medicaid fraud unit. So would the OIG work in conjunction with those units? And if people are coming from the BCA onto the OIG bill, and maybe this is a financial piece later, but would that money come out of the BCA budget into the OIG budget, or can you walk me through that a little bit?
Representative, who wants to answer that?
Either
You
one.
both do. Representative Anderson and then Norris. Go ahead.
The Attorney General is still responsible for Medicaid fraud and always will be by I think it's constitutional, it's not statute. But so that doesn't change, affect that essentially. The Inspector General has authority though to look at, everything. Does that make sense up here? So regarding the BCA fraud unit has been doing some Medicaid fraud, but mostly their insurance fraud, and that will always continue. So, thank you.
And Representative Norris, anything
Nothing
further?
further.
Okay, so Representative Steer?
Sorry, real quick. So if somebody is hired on the OIG out of the BCA, that would be a vacant position. Are we looking to eliminate any positions and add into the OIG bill? I assume we're going to tap into some of the fraud investigators we have now to get them into the OIG law enforcement area. Are we going to reduce somewhere? I'm just looking at the budget and where we're at.
Yeah, Representative Steer, I think you're a little ahead of us because I think we're still haven't adopted the amendment.
What?
Are you on the amendment? Okay, we're going to
I'm just
hold
excited,
that
Madam Chair.
question.
I'm excited.
Okay, yes, we're all very excited about this. Hold that question. So all in favor of adoption of the A13 amendment, please say aye. Aye. Any opposed? Motion prevails. Okay, Representative Steer, go ahead, please restate your
I've
question.
exhausted my efforts. No, thank you. Appreciate it.
Okay, Representative Norris?
Chair Liebling, I can just elaborate a little bit more on Representative Steer's question / point there. I do think it's an important thing that we're still wrestling with. figuring out, how do we make sure that we're not unnecessarily duplicating work that's already being done by other state agencies, that we're not creating unnecessary costs as we're creating the Office of the Inspector General. So I think, the questions you're asking are ones I'm asking as well, and I think we need to continue to explore before, I feel like this bill is in final shape and ready to head to the House floor.
Okay, other discussion? Representative Duran.
Thank you, Madam Chair. Looking at page 9 here, subdivision 2, parentheses C. Says the Department of Human Services has primary responsibilities to investigate fraud in Medicaid program, but the Inspector General has the authority to conduct independent investigation related to Medicaid program as necessary. And then in subdivision 3, you're alerting agency of issues seeking a court order to freeze funds. If the Department of Agency does not have a primary investigative authority under subdivision 2, the Inspector General shall investigate. Can you explain that to me, please?
Representative Norris.
Yeah, Chair Liebling, Representative Duran, that is something that we've spent a lot of time talking about as a working group. The challenge we have with agencies like DHS, DCYF, Department of Health that administer Medicaid dollars is there are federal rules that require any agency that is administering Medicaid dollars to have the primary program integrity responsibility for those dollars. And so we've tried to craft this bill in a way that still complies with those federal requirements, while also giving the OIG that concurrent authority to come in and investigate. Our hope is that those agencies will do the necessary program integrity work themselves, but if for some reason there's concern that that's not occurring, the OIG would have the ability to come in and do a concurrent investigation.
Representative Duran, more?
Thank you, Madam Chair. Yeah, follow up on that. And then is there anything in here that says that they have to cooperate with the OIG or DHS? Because can DHS just hold all this information and not cooperate or have anything else? And also with the BCA, with the investigative agencies, like who's bringing charges forward and everything like that. Is there anything inside here that would actually enable or hinder their ability to actually branch out and do actually share that information? Can DHS just be like, nope, we're done?
Yeah.
Representative Anderson.
Thank you, Representative Durant. I would have to read through and find the specific, but I can tell you that no, there's not. So there's specific language within this bill to make sure that they do cooperate and that the OIG actually has the authority to go in. There's a little bit of question about, because some states actually just do not have internal OIGs within some of their departments on Medicaid. And so there's some debate about whether, they have to have an OIG internally. But the program integrity unit in DHS, for example, is like 500 people. These are big, big, big units. And it's not just the OIG and their staff, but it's all the program integrity people below that. And so the idea of disrupting that and moving that into some other, it just doesn't make sense. At least not now. Maybe in 10 years, this legislature will change their mind about how to do that. But this OIG will have full authority to be in any, to look at any program within any state agency. But they're not necessarily going to be the ones that have the main, responsibility for it in places like DHS. Thanks.
Representative Norris.
Chair Liebling, I'll just tack on to that. I'll point members specifically to lines 14.15 to 14.18 in the data practices section. This is modeled closely off of the OLA's data practices section, and it gives the OIG access to data of any classification, including data classified as not public.
Yeah, thank you. Representative Van Binsbergen.
Thank you, Madam Chair. I got a question about this bill. I guess my question is, why is this taken so long. I mean, we've had so much fraud going on in Minnesota, $9 billion or more. We've had this to the House floor several times. The governor blocked this last time. Are we confident that it looks like this is finally pushing through? Are we going to get to the finish line with this, or are we going to get it back to the House floor and we're going to have the same problem again? I'm just curious of your opinion on that. And I'll make one other statement. It's sad that we've got to grow government more to pass a bill like this, because we've got the checks and balances, or we should have, within our agencies. I think the people that are in charge haven't been doing the job. And so we've had to create this new independent office, which I support fully. But I just want to make sure that we aren't going to get to the finish line here and the same thing happens again with the governor and your colleagues.
Chair
Well,
Liebling,
Representative Norris, I would just say that last piece is outside the scope of this committee, but go ahead, Representative Norris.
yeah, Chair Liebling and Representative Van Binsbergen, I am committed to working on getting an effective bill that is ready to do the work on day one. And yet, we've seen in both this committee stop and the last committee stop in state government that there's still clearly work that needs to be done on this bill. I mean, we just adopted several things that the OLA flagged that were concerning. In state gov, we had to make an amendment to even get the bill to be constitutional. So we are creating a really important entity, but it's also a very broad entity with a lot of sweeping powers, and we want to make sure we do this right so that it is ready to do the work on day one that Minnesotans expect it to do.
Yeah, thank you. I don't see anybody else on the list, and I just would like to I have a few things. Honestly, we're pretty much out of time here, and this bill could really use, I think, still a lot more scrutiny, and I'm awfully glad it's here in committee because there are a lot of data provisions. One thing that's still in this bill that I note is that it gives the OIG, the Office of Inspector General, the power to create another agency. And I have never seen that before in a bill. And the agency that it would create is another law enforcement agency. And I have all kinds of questions and things I would like to understand about that, which there is no time for today. But I also we are moving this today to Ways and Means, but in my opinion, this should go to public safety if it's going to create a law enforcement agency. I don't know how we skip that if we're creating one, and in large part because of the very thing that one of the members here brought up about overlapping powers. How do these things work together? Are we duplicating? Are we just wasting money? And, is this meaningful, or is this just saying we did something so that we can be against fraud? We're all against fraud. We hate fraud. Fraud wastes money that we want to go to vulnerable people or wherever we decide that it's important for it to go, never into the hands of fraudsters. We are all clear on that. And the question is, how can we best make sure that happens? And I just have some real concern about creating a new law enforcement agency that is not necessarily an efficient or even helpful thing to do. So that's a big concern that I have. I also have other kind of questions even about just a number of things. I'll just bring up one of them, for example, and maybe you can answer this quickly for me, Representative Norris or Representative Anderson. But so on the bill, we've got on line 12.17, inquiry and inspection power, duty to aid Inspector General. It says, all public officials and their deputies or employees, et cetera, let's see, shall at all times, and it lists a bunch of things about cooperation with the OIG, including provide returns and reports required by the Inspector General. Now, earlier in the bill, public officials includes all of us, us and a lot of our higher level staff, et cetera. And I'm just really wondering, that seems to include the legislative branch, and I have just a concern there, again, about one branch intruding on another branch. And maybe I'm just being hyper vigilant there, but I just wonder if that's what's intended. That's one of the many concerns that I still have about the bill, just flagging it. I wish we had another hour to spend on this bill because it's that important to get this right. But Representative Anderson, you look like you might have an answer for me.
Thank you, Chair Leva. We can't find the exact, you said 1217?
12.17.
12.17.
Oh, I'm on the DE6.
Yeah, you might be
I'm
on a.
sorry, I'm on the wrong one. Okay.
So-
This is the one I took home with me and worked.
And Chair Liebling, I think, and I'm getting the nod from
Yeah.
our legislative auditor, I think that definition of public officials has been adjusted as part of the A13
yeah.
amendment that we adopted today. So you were right to flag it as a concern, and I
Okay.
think we have hopefully addressed it to some level of satisfaction.
Okay, and then, so I think I probably should stop because we are way past our extra time here, and I know people need to get going, but I do, maybe I'll talk with one or both of you about some of my other concerns offline, but thank you for your work on this. This is really a gargantuan task, and, let's not get lost in, how long it takes to get this through, and this is something that is so important for us to get it right, because we want to prevent fraud in the state the absolute best we can. And of course, any bill that ever passes has to be adjusted in future years as we learn more. That is a given. But we want to get this as right as we can. We don't want to waste any more public dollars doing things that actually make it harder to catch and prevent fraud. And I really appreciate both of you working on this. I appreciate the bipartisanship and the work that's been done. And so, do you want to make a final comment, either of you, besides my final comment there?
No, Chair Liebling, appreciate the hearing from the committee.
All right, thank you very much. So with that, I'm going to renew my motion that House File 856, Senate File.
Yeah.
Oh, that's hard to say. Senate File 856, the first engrossment as amended, be re-referred to Ways and Means. All in favor, please say aye. Aye. Any opposed? The motion prevails. And so just before we adjourn, this is our last hearing before the break. I hope you will all have a wonderful holiday, a good rest. We will continue after the break. So we stand adjourned.